Case 1. Christina Schroer, November 2020, Rose Hill, Butler County, Kansas, Butler County District Court. There is a particular kind of quiet that settles over a small Kansas town, the kind where everyone believes they know their neighbors, where a school pickup line and a church potluck are enough to convince a community that nothing truly dark could ever take root nearby. Rose Hill, Kansas, is that kind of town. Population small enough that word travels fast, close enough to Wichita to feel connected, far enough removed to feel safe. It was in this town, behind an ordinary front door, that one of the most devastating child abuse cases in recent Kansas history was allowed to hide in plain sight for nearly 4 years. Christina Schroer and her husband Joseph had built a public image as a family who gave vulnerable children a second chance. In November 2019, the couple formally adopted 5 sisters, girls who had spent time in the Kansas foster care system before the Schroers took them in. On paper, it read like a success story. A family growing, children finally finding permanence. One of those girls was Natalie Marie Garcia, born in July 2014. After her adoption, she was given a new name, Kennedy Jean Schroer, a name that would follow her in official records for years, even as the truth of what happened to her lay buried and unspoken. By the time investigators pieced together the full picture years later, they would describe a household that operated less like a family and more like a system of control, one in which even the smallest infractions, a child moving too much in her sleep, a look interpreted as defiance, could trigger disproportionate, dangerous discipline. In November 2020, Natalie's crime, if it can even be called that, was moving during the night. It was the kind of restlessness expected of any 6-year-old. Christina Schroer's response was anything but ordinary. She forced her daughter into a small reinforced cardboard box, sturdy enough to contain a child, small enough to leave her with almost no room to move. To make certain Natalie could not escape, and to muffle any sound she might make, Schroer piled heavy blankets on top of the box, along with additional household objects to weigh it down further. In the dark, enclosed space, with no ventilation and no way to call for help, Natalie Marie Garcia suffocated. What Schroer did in the hours and days that followed reveals as much about her as the act itself. She did not call 911. She did not seek help. Instead, according to what investigators would later reconstruct, she drove around with her daughter's body for hours, apparently working through what her next move would be, before ultimately returning to the family's Rose Hill property. There, just outside the master bedroom window, she buried Natalie in a shallow, concealed grave. And then, for nearly 4 years, Christina Schroer lived a double life. To the outside world, to extended family, to neighbors, to the state's child welfare system, she maintained an elaborate story. Natalie had been removed from the home and placed in a psychiatric treatment facility after allegedly attacking a younger sibling. It was a plausible enough story that it went largely unquestioned. Family members asked after Natalie over the years. Schroer had an answer ready every time. The lie held together because almost no one had reason to doubt a mother who, by every outward appearance, had done something generous and difficult. Taking in children the system had failed. Behind that constructed narrative, the surviving children in the home were living through their own ongoing nightmare. Investigators would later reveal that one of Natalie's sisters had actually attempted to report the abuse in 2021, running away from the home and telling authorities what had happened. But without a body, without physical evidence, and against the backdrop of a household that presented itself so convincingly to caseworkers, the report could not be substantiated at the time. The system that was supposed to catch this failure did not catch it. Schroer's deception was, investigators later admitted publicly, effective enough to fool the very people whose job it was to see through it. The truth surfaced in September 2024, when police responded to a call at the Schroer residence. Christina had reportedly taken a combination of pills on top of her heart medication, telling responders that her life was over and that no one would ever look at her the same way again. When officers asked her why, the explanation that followed set off a chain of events that would finally bring Natalie home. One of Natalie's sisters, present in the home, could no longer carry the weight of what she had witnessed years earlier. She told police the truth, that Natalie had been placed in a box, that objects had been piled on top to keep her from moving, and that she had never come out alive. Investigators secured a search warrant for the property, using cadaver detection equipment and eventually heavy excavation machinery to clear the overgrown yard. They searched the ground near the home's master bedroom. What they found confirmed the sisters' account in full. Natalie's remains, wrapped and buried exactly where she had said they would be. A forensic examination by the Sedgwick County Forensic Science Center determined that Natalie had died of suffocation, consistent with the account investigators had been given. The surviving children, removed from the home and placed into protective custody, showed the physical toll of years spent under Schroer's control. One child, according to court records, had entered the household in 2017 in the 75th percentile for weight, a healthy, thriving child, and had fallen to below the 5th percentile by the time she was finally removed in 2024. The picture that emerged was not of an isolated tragedy, but of a sustained pattern of severe neglect and abuse across multiple children, unfolding for years while the community around the Schroer family saw nothing but a devoted adoptive mother. Christina Schroer was arrested and charged with an array of felonies tied to Natalie's death and the broader pattern of abuse in the home. Facing the possibility of a far harsher sentence if convicted at trial on the most serious charges, she ultimately entered a plea. On November 10, 2025, she appeared before Judge Jan Satterfield in Butler County District Court and pleaded to charges including second-degree murder, child abuse, making false information, and theft by welfare fraud, the last charge reflecting the fact that Schroer had continued to collect state benefits tied to Natalie for years after her death, using the very fiction she had constructed to keep the money flowing. At sentencing, Natalie's biological mother, grandmother, and sister addressed the court. Her mother, Krista Helm, spoke through tears, asking why her daughter had been taken and describing a little girl whose smile, she said, could light up an entire room. Judge Satterfield did not mince words in response. She told Schroer directly that she had betrayed everyone, her own family, Natalie's family, and the broader community that had trusted her. The judge imposed the maximum sentence available under the plea agreement, 215 months, just shy of 18 years, with every count ordered to run consecutively. Schroer will also be required to register as a violent offender for 15 years following any eventual release. In their statement following sentencing, the Rose Hill Police Department did not soften their assessment of what had occurred, calling the outcome nowhere near a high enough price for what they described as the prolonged suffering inflicted on a beautiful 6-year-old child. It was an unusually candid acknowledgement from law enforcement, a recognition that a legal resolution, however severe, could never fully answer for what 4 years of silence had cost. Natalie Marie Garcia's story is, in many ways, a story about how thoroughly a determined abuser can manipulate the systems built to protect children, child welfare caseworkers, extended family, an entire community. It is also, ultimately, a story about the courage of a child, Natalie's own sister, who broke a silence that had held for nearly 4 years, and in doing so, finally brought her sister home. If you or someone you know is concerned about a child's safety, the Child Help National Child Abuse Hotline is available around the clock at 1-8004-ACHILD, staffed by professional crisis counselors who can help. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. Before we move on to the next case, take just 2 seconds to make sure you're subscribed so you never miss another gripping true crime documentary. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. Case 2. Jacqueline Kirkpatrick. July 2020. Kansas City, Wyandotte County, Kansas. Wyandotte County District Court. Olivia Jansen was 3 years old. Those who knew her would later describe her in courtrooms and in victim impact statements, using the same words again and again: bubbly, full of hope, full of life. She should have been days away from starting preschool, learning her letters, chasing other toddlers around a playground. Instead, in the summer of 2020, she became the center of one of the most heartbreaking child death cases Wyandotte County has ever prosecuted. Olivia lived with her father, Howard Jansen III, and his girlfriend, Jacqueline Kirkpatrick, in Kansas City, Kansas. To understand what happened to Olivia, it's important to understand what her life inside that home had already become in the months before her death. According to prosecutors, Kirkpatrick routinely confined the toddler inside a cramped wire dog kennel, treating a 3-year-old child the way one might treat an unruly animal. When Olivia was allowed out of the kennel, she was frequently forced to stand motionless in a corner for extended stretches of time, a punishment far beyond anything appropriate for a child her age. This was not a household that escaped scrutiny entirely. Records later revealed that Kansas police had been called to Olivia's home 5 separate times in 2020 alone, prior to her death. Kansas's Department for Children and Families had also been contacted with concerns. And yet, for reasons that would become a painful subject of public debate after Olivia's death, the warning signs did not result in her removal from the home in time. In July 2020, the pattern of abuse in that household reached its fatal conclusion. According to the case laid out by prosecutors, Kirkpatrick struck the back of Olivia's head. In some instances, witnesses in the home told investigators, slamming it against a wall. The injury caused significant bleeding on the back of the little girl's brain, an injury from which she would not recover. What Kirkpatrick and Jansen did next transformed a private tragedy into a public spectacle that consumed the Kansas City community for a full day. Rather than seeking emergency medical help or notifying authorities of what had actually happened, the couple constructed and reported an entirely fabricated story, that Olivia had gone missing from the home, taken by an unknown party. The claim triggered a full Amber Alert, an emergency broadcast that mobilized law enforcement agencies, media outlets, and ordinary residents across the region, all searching urgently for a missing child who prosecutors say was, by that point, already gone. For hours the search played out publicly. Volunteers combed neighborhoods. News crews broadcast Olivia's photo across the region. And throughout it all, investigators working directly with Jansen and Kirkpatrick began noticing inconsistencies in their accounts of what had happened that morning. Details that didn't line up, timelines that shifted with each retelling. A police spokesperson later put it plainly. They heard several different stories throughout the day, and none of them made sense. By that evening, the search reached its devastating end. Olivia's body was found in a wooded area not far from her own home, roughly 9 blocks away, near South 34th Street and Steel Road. She was dressed in the pajamas she had likely been wearing the last time anyone outside the home saw her alive, with bruising on her body that investigators would later connect to the sustained pattern of abuse described by other children in the household. The investigation that followed built a case against both Jansen and Kirkpatrick. Kirkpatrick was booked on charges of murder and child abuse. Jansen faced the same. As evidence mounted, including accounts from other children in the home describing Kirkpatrick's treatment of Olivia in the kennel, in the corner, and in the moments surrounding her death, Kirkpatrick's legal team recognized the strength of the state's case. In November 2021, she pleaded guilty to second-degree murder, abuse of a child under the age of 6, and 2 counts of interference with law enforcement, tied to the false report that had triggered the Amber Alert. Her sentencing hearing, held in December 2021 in Wyandotte County District Court, was, by every account, an emotionally devastating proceeding. Family members delivered victim impact statements describing a little girl who would never celebrate another birthday, never start kindergarten, never grow beyond the age of 3 in the memories of the people who loved her. Several relatives used their time before the court to raise pointed criticism of Kansas's child welfare system, expressing their belief that the Department for Children and Families and law enforcement had missed opportunities to intervene before it was too late, a theme that would recur in public discussion of the case for years afterward. The judge sentenced Kirkpatrick to 376 months in prison, just over 31 years, with credit granted for the roughly year and a half she had already spent in custody awaiting trial. As part of her plea agreement, Kirkpatrick was required to testify against Howard Jansen III, who faced his own first-degree murder charge, along with aggravated child endangerment and desecration charges, in a separate prosecution. 2 days after Kirkpatrick's sentencing, Olivia Jansen would have turned 5 years old. Near the intersection where her body was found, a memorial grew in the months and years that followed, balloons, teddy bears, small crosses, and angel figurines lining the street. A community's way of ensuring that a little girl who was silenced far too soon would not be forgotten. Her family has said, in the years since, that in their memory, Olivia will always be 3, never older, never given the chance to become anything more than the bubbly, hopeful child she was in the short time she had. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. Before we move on to the next case, take just 2 seconds to make sure you're subscribed so you never miss another gripping true crime documentary. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. Case 3. Rachel Hilliard, April 9, 2017. Wichita, Sedgwick County, Kansas. Sedgwick County District Court. There are crime scenes that investigators describe in careful, clinical language, and then there are the rare few that veteran officers say they will never fully shake from memory. April 9, 2017, in a modest home on West Rita Street in Wichita, Kansas, became one of those scenes. A day that began as nothing more than a routine, almost mundane errand, and ended in a level of violence that would leave an entire community searching for an explanation that never quite arrived. To understand what happened that afternoon, you have to understand the relationships tangled up inside it. Rachel Hilliard had recently split from her boyfriend. His mother, 63-year-old Mickey Davis, still had a practical matter to settle. Some of her son's remaining belongings were still at Hilliard's home, and someone needed to collect them. There was nothing unusual about the errand itself. Davis brought along her 9-year-old grandson, likely expecting little more than an awkward but brief exchange between two people whose relationship to each other had recently changed. What triggered the events that followed has never been fully, satisfyingly explained, not by investigators, not by the courts, and not, ultimately, by Hilliard herself. By her own account, and by the account prosecutors would later present at trial, an argument broke out inside the home over something almost absurdly small in proportion to what came next: ownership of a painting. Witnesses and later court testimony suggest the disagreement escalated with startling speed, moving from words to physical violence in what may have been only a matter of moments. Hilliard attacked Mickey Davis. What began as a physical altercation inside the house moved into the garage, with Hilliard overpowering the older woman. It was in this chaos that 9-year-old boy, Davis's own grandson, did something that investigators and prosecutors would later describe as remarkable given his age and the terror of the moment. Rather than freezing, rather than staying to watch what was happening to his grandmother, he ran. He made it to his grandmother's truck, parked outside, grabbed her cell phone, and dialed 911 while fleeing the property on foot, reporting to the dispatcher that his grandmother was being attacked inside the home. Those minutes, the time between the child's escape and the arrival of the first patrol officers, would prove to be the most consequential of the entire case. According to the account prosecutors laid out at trial, Hilliard used that window to drag Mickey Davis deeper into the garage. She retrieved kitchen knives, ordinary steak knives, the kind found in nearly every American home, and, according to the prosecution's case, used them to inflict fatal injuries so severe that when the first officers arrived on scene, they found Davis's body separated from her head, which had come to rest inside the kitchen sink. Officers found Hilliard inside the residence. She did not resist. What she offered instead, in the hours and days that followed, was an explanation that would come to define the entirety of her legal defense. She said she believed, in the moment, that some kind of evil or demonic presence had taken hold of the situation, and that by the actions she took, she was somehow releasing Mickey Davis's soul from her body, an account she would repeat, largely unchanged, for years afterward, including from the witness stand at her own trial. The case that followed was in many ways a battle over a single question. Was this the act of someone in the grip of a genuine, incapacitating psychiatric break, or was it the act of someone who understood exactly what she was doing and chose, in a moment of uncontrolled rage, to do it anyway? Hilliard was evaluated and treated at a state psychiatric facility before being declared competent to stand trial, a legal determination that meant whatever her mental state at the time of the crime, she was capable of understanding the charges against her and assisting in her own defense. At trial, prosecutors, led by then Sedgwick County District Attorney Mark Bennett, methodically built a case designed to counter the insanity narrative. They argued that whatever internal turmoil Hilliard may genuinely have experienced, the physical evidence at the scene told a story of clarity, not chaos, a deliberate, sustained act carried out with intention, not a psychotic episode disconnected from reality. Bennett's closing arguments to the jury were, by most courtroom accounts, blunt. For reasons that may never be fully understood, Hilliard had decided she'd had enough of Mickey Davis, and she acted on that decision with lethal, deliberate force. Hilliard herself took the stand during her trial, an unusual and often risky decision for a capital defendant, but one her legal team believed was necessary given the centrality of her mental state to the entire case. She described losing control during the argument, describing it in her own words as simply freaking out, before the situation spiraled beyond her ability to stop it. It was, by any measure, a difficult and haunting piece of testimony for the jury to weigh against the physical evidence of the crime scene itself. In February 2020, after considering the competing narratives, a Sedgwick County jury reached its verdict: guilty of first-degree premeditated murder. The word premeditated mattered enormously here. It meant the jury had rejected the defense's core argument, finding instead that Hilliard's actions, however disturbing their stated justification, reflected planning and intent rather than an uncontrollable break from reality. At sentencing months later, Hilliard addressed Mickey Davis's family directly, several of whom had traveled to be present in the courtroom, with others joining by video call. She told them that she believed even death would be too light a punishment for what she had done, and that she thought of what happened every single day. Sedgwick County District Court Judge Bruce Brown, addressing Hilliard before pronouncing sentence, said he found himself struggling for the words to describe what he called an act with no discernible humanity left in it. He imposed the sentence Kansas law describes as a hard 50, a life sentence carrying no possibility of parole until 50 years have been served, effectively ensuring Hilliard, in her late 30s at the time of sentencing, would likely spend the remainder of her natural life behind bars. Hilliard did not accept the verdict quietly. Her defense team pursued a lengthy appeal, arguing to the Kansas Supreme Court that the evidence had been insufficient to support a finding of premeditation, that jury instructions had been flawed, that her trial counsel had been ineffective, and that prosecutorial errors and abuses of discretion by the trial court had combined to deny her a fair trial. The state's highest court took the unusual step of hearing oral arguments in a special evening session held in a ballroom in Great Bend, Kansas, to accommodate public interest in the case. In August 2022, the justices issued their ruling. Every one of Hilliard's arguments was rejected. Her conviction and her hard 50 sentence were affirmed in full, closing the door on her primary avenue of appeal and confirming that barring some future legal development, Rachel Hilliard will spend the next several decades of her life in a Kansas prison. For Mickey Davis's family, the case has always carried a strange duality. Profound grief over the sudden, shocking loss of a mother and grandmother, paired with what relatives have described as a measure of relief and pride in the actions of the 9-year-old boy who witnessed it all. His decision to run, to find a phone, to call for help rather than freeze in fear, meant that whatever else was lost that day in April 2017, the truth of what happened to his grandmother was never in doubt, and justice, however painfully delayed by years of appeals, was ultimately delivered. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. Before we move on to the next case, take just 2 seconds to make sure you're subscribed so you never miss another gripping true crime documentary. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. Case 4. Kimberly Nybarger, April 2023, Parsons and rural Neosho County, Kansas, Neosho County District Court. Not every case in this documentary revolves around a parent, a caregiver, or the betrayal of a child's trust. Some of the most chilling Kansas cases involve something colder still. 2 adults, bound together not by love, but by a shared willingness to plan and carry out the death of another human being, followed by a bizarre attempt to game the legal system itself. Dakota Patton was 23 years old, a young man from Parsons, a small city tucked into the southeastern corner of Kansas, not far from the Oklahoma border. By the accounts of those who knew him, he was well liked in his community. Someone with friends, with a family who cared about him, with an ordinary life ahead of him that gave no indication it was about to be cut brutally short. Patton knew Clint Nybarger, a Parsons man with whom he had an on-again, off-again friendship. On the evening of April 25, 2023, the two crossed paths at a local gas station, where witnesses would later recall the 2 men arguing, reportedly over a woman both had some connection to. It was, by most accounts, the kind of heated but ultimately unremarkable dispute that plays out at gas stations and parking lots across the country every single day. For Dakota Patton, it would be among the last interactions of his life. What Patton did not know, what almost no one around him knew, was that Clint Nybarger and his girlfriend Kimberly had already discussed killing him. The exact motive behind that decision has never been fully, publicly detailed, in a way that makes rational sense of the disproportionate violence that followed, but court records make clear that the plan predated the gas station confrontation. Kimberly, prosecutors would later establish, did not simply stand by as a bystander to her boyfriend's actions. She actively drove him and an unsuspecting Dakota Patton out to a remote rural stretch of Neosho County, an area isolated enough that a crime committed there might go undiscovered for a considerable period of time. Once they arrived at that desolate location, Clint Nybarger shot Dakota Patton in the face, killing him where he stood. The two then left his body in the field and worked to distance themselves from the scene, positioning his vehicle separately in a rural area of neighboring Labette County, his tires deliberately damaged, designed to suggest an unrelated incident rather than point investigators toward what had actually occurred. For Patton's family, the days that followed were an agonizing open wound. His brother Patrick would later describe those 13 days as an unrelenting nightmare, knowing something was deeply wrong, but with no answers, no leads, no way to bring their missing loved one home. The family conducted their own grid search of the area near where Patton's abandoned truck was discovered, working alongside volunteer firefighters and the county sheriff's office, refusing to simply wait for news that might never come. While the search for Patton continued, Kimberly and Clint made a decision that would come to define the strangest chapter of this entire case. On the very same day that Patton's abandoned vehicle was discovered by investigators, the same day that should have told them the walls were closing in, the couple traveled across state lines and got married in a quick, informal ceremony in Oklahoma. Their reasoning, as it was later understood by investigators and reported in court filings, rested on a serious misunderstanding of how the law actually works. They apparently believed that becoming legally married would grant them an ironclad form of spousal privilege, permanently shielding each of them from ever being compelled to testify against the other in a criminal proceeding. Almost immediately after the wedding, the newlyweds fled to Missouri, ostensibly for what they treated as a honeymoon, staying for several days with acquaintances in Hollister before their eventual capture. Investigators, working across multiple agencies and state lines, were not far behind. Dakota Patton's remains were discovered on May 8, 2023, in a rural field in Neosho County, roughly a mile from where his family had already conducted their own desperate search. A medical examination confirmed what everyone had feared. He had died of a gunshot wound. Arrest warrants for first-degree murder and conspiracy to commit murder were issued for both Clint and Kimberly. That same evening, officers with the Taney County Sheriff's Office in Missouri located Kimberly leaving a residence in Hollister and took her into custody. Clint was apprehended in the same area shortly afterward. The spousal privilege strategy the couple had gambled on ultimately provided little protection once prosecutors began assembling their case. Independent evidence, including statements the couple had reportedly made to acquaintances during their brief time in Missouri, describing what had happened to Patton in unsettling detail, gave investigators more than enough to proceed regardless of any marital testimonial privilege. According to later court testimony, Clint had told friends he shot Patton and left his body where it fell. Kimberly had reportedly asked those same acquaintances for help moving the body, a request they refused. Both defendants were extradited back to Kansas to face justice in Neosho County District Court. Clint Niebarger ultimately waived his right to a jury trial and pleaded guilty to an amended charge of intentional second-degree murder, along with conspiracy to commit first-degree murder. Prosecutors and his defense jointly recommended a sentence structure that would see him serve roughly 24 years, 176 months on the murder count and 117 months on the conspiracy count, served consecutively. Kimberly Niebarger's case followed a separate but related path. She initially entered a not guilty plea, but as the evidence against both defendants continued to solidify, including testimony that would later be used against her husband, she ultimately agreed to a plea deal of her own. She pleaded guilty to conspiracy to commit first-degree murder and obstructing apprehension, agreeing as part of the arrangement to testify against her husband if called upon to do so. In April 2025, she was sentenced in Neosho County District Court to 117 months in prison, just under 10 years. What makes this case linger for investigators and for the public who followed it isn't any singular act of extreme brutality in the way some of the other cases in this documentary series involve. It's the almost incomprehensible calculation behind it. Two people who discussed ending a young man's life beforehand carried out that plan in a remote field, and then, rather than fleeing in panic or turning themselves in, took the time to get legally married in what they believed was a clever, foolproof shield against justice. It wasn't. Dakota Patton's family got the answers they spent 13 agonizing days searching for, and both people responsible for taking him from them are now serving lengthy sentences in the Kansas prison system. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. Before we move on to the next case, take just 2 seconds to make sure you're subscribed so you never miss another gripping true crime documentary. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. Case 5. Dana Chandler, July 7, 2002. Topeka, Shawnee County, Kansas. Shawnee County District Court, later retried in Pottawatomie County District Court. Some cases resolve within weeks. Some take years. The case against Dana Chandler took 23 years, 3 separate trials, the disbarment of a prosecutor, and the testimony of the very children she raised, and even then, it very nearly never reached a conclusion at all. To understand the murders of Mike Cisco and Karen Harkness, you first have to understand the years that preceded them. Dana Chandler and Mike Cisco had been married, and by every account that would later surface in courtrooms and in extensive national television coverage, their divorce did not end cleanly. Family members and law enforcement would later describe a pattern that escalated steadily in the years after the marriage dissolved. Chandler's fixation on her ex-husband, they said, never seemed to fade the way most people's does after time passes. Instead, according to prosecutors, it hardened into something closer to obsession. When Cisco moved on and began a new relationship with Karen Harkness, a woman in her early 50s building a life of her own in Topeka, that obsession reportedly found a new target as well. Cisco eventually obtained a formal protection from abuse order against Chandler, a legal acknowledgement sought while he was still alive, that he genuinely feared what she might do. On the night of July 7, 2002, someone entered Karen Harkness's Topeka duplex while she and Mike Cisco slept. Whoever it was made their way upstairs to the master bedroom and opened fire on the sleeping couple. Cisco was struck 7 times. Harkness was struck 5 times. Neither survived. Family members discovered their bodies later that day, beginning a legal odyssey that would not reach any final resolution for more than 2 decades. From the earliest days of the investigation, Chandler's name surfaced as the presumed prime suspect. Her history with Cisco, the protection order, the pattern of behavior described by those who knew the couple all pointed in one direction. And yet, in the crucial early months when physical evidence is most likely to be found and preserved, investigators came up empty in ways that would haunt the case for years. There was no DNA connecting Chandler to the scene, no fingerprints on the shell casings left behind, no hair or fiber evidence tying her to the duplex. The murder weapon itself was never recovered, despite years of searching. Chandler's own vehicle, when eventually examined, showed no signs connecting it to any crime. For 9 full years, Dana Chandler lived as a free woman while the Cisco and Harkness families were left to watch a case that everyone believed they understood go essentially nowhere. The break, when it finally came, wasn't driven by new forensic technology or a surprise confession. It came from persistence, a renewed investigative push, reportedly given fresh momentum after a 2009 television news magazine special on the unsolved case reignited public attention and pressure. In 2011, a new Shawnee County District Attorney reviewed the accumulated circumstantial case and made the decision his predecessor had not. Chandler was arrested and charged with 2 counts of first-degree murder. Her first trial, in 2012, produced a conviction. A jury, after hearing weeks of testimony that included Chandler's own adult children, who were 15 and 17 years old at the time of the murders, testifying against their own mother, found her guilty on both counts. She was sentenced to life in prison. For a time, it appeared the case was finally, fully closed. It was not. Years later, Chandler's legal team uncovered what would become one of the most consequential findings in the entire saga. The lead prosecutor in her 2012 trial, Jackie Spradling, had made statements to the jury about supposedly existing evidence, specifically involving the protection from abuse order and Chandler's alleged awareness of it, that were, according to the Kansas Supreme Court's eventual review, simply not supported by anything actually in the record. In 2018, the state's highest court took the serious step of overturning Chandler's conviction entirely, citing what the justices described as flagrant, deliberate prosecutorial misconduct. Spradling was subsequently disbarred from the practice of law altogether, a professional death sentence for the attorney who had once secured Chandler's conviction, and a legal earthquake that sent the entire case back to square one. A second trial followed in the summer of 2022. This time, the prosecution, now aware they needed to rebuild their case on a foundation that could withstand the same scrutiny that had brought down the first conviction, leaned almost entirely on circumstantial evidence and a narrative of motive, jealousy, obsession and rage, argued without the benefit of DNA, a weapon or a confession. After 6 grueling days of deliberation, the jury deadlocked. 7 jurors believed Chandler was guilty. 5 believed the state had not proven its case beyond a reasonable doubt. A hung jury meant no verdict at all, and after more than a decade in custody, Chandler was released on significantly reduced bond with GPS monitoring while prosecutors decided whether to try a third time. They did. The The third trial began in February 2025, relocated to Pottawatomie County, roughly 60 miles from Topeka, following a defense request for a change of venue. In a decision that stunned courtroom observers, Chandler dismissed her defense attorneys on the very morning opening statements were set to begin and elected to represent herself for the remainder of the proceedings, cross-examining witnesses, delivering her own closing argument, and telling the jury directly, in her own words, that she was innocent and had always maintained that innocence. The most powerful moment of the trial, by nearly every account of those who covered it, came from Chandler's own daughter. Haley Seal, who had been 17 years old when her father was murdered, returned to the stand more than 2 decades later to describe, in a victim impact statement delivered directly to her mother, a lifetime consumed by uncertainty, grief, and the slow, painful process of coming to a conclusion she never wanted to reach. She told the court that she had come to see her mother as the person responsible for her father's death. Testimony she would later describe in television interviews after the trial concluded as one of the hardest things she has ever done in her life. In March 2025, after deliberating for roughly 4 hours, the jury returned its verdict, guilty on both counts of first-degree murder. On June 3, 2025, Chandler stood before the court for sentencing as family and friends of both victims packed the gallery. Haley Seal addressed her mother one final time, telling her she now saw her clearly, as in Seal's own words, the person responsible for taking her father's life, and expressing hope that the public conversation around the case, which had for years centered on Chandler herself, might finally shift its focus back to the 2 people who were actually killed. The presiding judge sentenced Chandler to 2 consecutive life terms, ensuring she must serve a minimum of 50 years before any possibility of parole, a sentence handed down 23 years, almost to the month, after Mike Sisko and Karen Harkness were killed in their sleep. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. Before we move on to the next case, take just 2 seconds to make sure you're subscribed so you never miss another gripping true crime documentary. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. Case 6. Elizabeth Woolhater, May 2018, Wichita, Sedgwick County, Kansas, Sedgwick County District Court. Some of the cases in this documentary series involve strangers, ex-partners, or people connected only loosely to their victims. This one involves a mother, a 2-year-old boy, and a single devastating moment over something as ordinary as breakfast, a moment that would expose not only one household's failures, but the failures of an entire state system meant to protect children just like him. Anthony Bunn, known to his family as Tony, was 2 years old in May of 2018, living in Wichita, Kansas, with his mother, Elizabeth Woolhater, and her boyfriend, Lucas Deal. By every measure that matters in a case like this, Tony was a child who should have been protected. And, according to records that would only come to light after his death, he was a child whose danger had already been flagged to the very state agency responsible for catching exactly this kind of situation. On the day that would become the center of this case, Tony refused to eat a hot dog. It is almost impossible, viewed from any reasonable perspective, to comprehend how such an ordinary act of childhood defiance, the kind every parent of a toddler has experienced in some form, could trigger what followed. According to the account Woolhater herself would later give investigators, she lost it. She struck her son. When her boyfriend, Lucas Deal, became involved, he continued the assault, inflicting further, more severe harm on the small boy, while, according to prosecutors, Woolhater stood by rather than intervening to stop him. What happened in the hours immediately after may be the single most damning part of the entire case. Rather than calling emergency services, rather than rushing her unconscious son to the nearest hospital, Woolhater later admitted that she did not know whether his condition was, in her own words, dire enough to justify calling for medical help. That hesitation, whether born of fear that hospital staff would recognize signs of prior abuse, fear of the legal consequences that would follow, or some combination of both, cost precious time that Tony Bunn did not have. He was eventually found by responding officers with severe injuries to his head and face, not breathing. He was rushed to the hospital, where he clung to life for 2 agonizing days before ultimately succumbing to his injuries. The autopsy that followed revealed something far more disturbing than a single isolated incident of parental rage. Medical examiners documented a broken nose, a fractured arm, a broken rib, and extensive bruising across Tony's face, back, stomach, and buttocks. Physical evidence of what investigators would describe as a sustained pattern of abuse that had been inflicted on the toddler over an extended period, not a single catastrophic loss of temper. And then came the detail that transformed this from a devastating family tragedy into a genuine statewide scandal. Investigative records obtained by local journalists in the aftermath of Tony's death revealed that Kansas's Department for Children and Families had received a report about suspected abuse in the household a full 7 months before Tony died. The warning had come from within Tony's own extended family. His grandmother, alarmed by what she had observed, had done exactly what she was supposed to do. She reported her concerns to the state agency charged with investigating them. According to the reporting that followed, the agency's response fell critically short. Key follow-up steps that might have led to Tony's removal from the home, steps that, in hindsight, likely would have saved his life, were never completed. Lucas Deal was the first of the 2 adults in the household to face justice. He was charged with felony murder and proceeded to trial, maintaining throughout that Tony had been injured in an accidental fall from a bed, a claim that failed to persuade the jury given the extensive pattern of prior injuries documented in the autopsy. He was convicted and, in a Sedgwick County courtroom, sentenced to 586 months in prison, just under 49 years. At his sentencing, Deal addressed the court directly, offering an apology and stating that he took full responsibility for what had happened to Tony. Elizabeth Woolheater's case followed roughly a year later. Facing charges of felony murder and aggravated child abuse, and with the physical evidence and the DCF failure now a matter of intense public scrutiny, she made the decision to forego a jury trial entirely. In August 2019, she pleaded guilty to second-degree murder and 2 counts of child abuse. At her sentencing hearing that October, Tony's grandmother, the same relative who had tried, 7 months before his death, to warn the system that failed him, addressed the court, saying that if Tony could ask his mother one question, it would simply be, why? Why didn't she protect him? Why didn't she love him enough? The judge sentenced Woolheater to 19 years and 5 months in state prison, a sentence significantly shorter than Deal's, reflecting her role as the parent who failed to intervene and failed to seek timely help, rather than the one who inflicted the most severe physical injuries directly. In the years since, Tony Bunn's case has been repeatedly cited by child welfare advocates and Kansas lawmakers examining the gaps in the state's reporting and follow-up systems, a painful, concrete example of what can happen when a warning is given but not acted upon in time. If you suspect a child in your life may be experiencing abuse or neglect, Kansas residents can make a report directly to the state's Protection Report Center, and the National Child Help Hotline at 1-800-4ACHILD is available around the clock to help anyone anywhere take that first step. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. Before we move on to the next case, take just 2 seconds to make sure you're subscribed so you never miss another gripping true crime documentary. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. Case 7. Margaret E. Schaaf. February 19, 2024. Fort Riley Military Installation, Geary, Riley County, Kansas. United States District Court for the District of Kansas. Fort Riley is one of the U.S. Army's largest and most storied installations, a sprawling post in north-central Kansas that has been home to generations of soldiers and their families. It is a place built around structure, discipline, and the particular kind of trust that military families extend to one another. The understanding that the person you share a home with on base is, in some sense, sharing in the same mission, the same sacrifices, the same life. On February 19, 2024, that trust was shattered inside a single home on that base, in a killing so disturbing in its details that it would ultimately require a federal jury, rather than a state one, to deliver justice. Greg Schaaf was 35 years old, an active-duty United States Army soldier who had orders to deploy overseas to Poland that very day. It would have been, for most soldiers, an unremarkable if difficult departure, another rotation, another period of separation from family and service of the mission. But Greg made a different choice. In the days leading up to his scheduled departure, his wife Margaret had been hospitalized with severe complications related to her pregnancy, complications serious enough that their newborn child was placed in the neonatal intensive care unit. Rather than deploy as scheduled and leave his family to navigate that crisis without him, Greg made the decision to delay his departure, to stay behind at Fort Riley, at least for a short while, to be present for his wife and his newborn child during one of the most vulnerable moments a young family can face. Within 24 hours of that decision, a decision by every indication rooted entirely in care and responsibility toward his family, a violent and explosive domestic confrontation erupted inside their on-base home. What makes the record of that day so unusually clear and so difficult to hear is a piece of evidence Greg himself created in the minutes before he was killed. A recording made on his own phone, capturing his wife's escalating rage. On that audio, later played for the federal jury that would decide Margaret's fate, she can be heard screaming that she was going to kill him, that she wanted him dead, that she hoped he would die. It was not an ambiguous domestic dispute captured after the fact through second-hand testimony. It was, in Margaret's own recorded voice, an explicit and repeated threat against her husband's life, made only moments before that threat became reality. Despite Greg's pleas, Margaret retrieved a firearm and shot her husband directly in the face. At the moment she pulled the trigger, according to evidence presented at trial, Greg was actively holding their 11-month-old infant daughter in his arms. What followed inside that home in the minutes after the shooting reveals both the horror of the moment and an extraordinary act of composure from a child far too young to have been asked to summon it. Mortally wounded, Greg made his way into a bathroom, where his 9-year-old stepdaughter happened to be brushing her hair, entirely unaware of what had just occurred elsewhere in the house. Rather than panicking, the young girl grabbed her infant half-sister, took shelter with her in the shower, and used a cell phone to place a video call to her biological father, who lived in Nebraska. Through that call, he was able to see enough of what was happening to understand the severity of the situation, and he immediately contacted emergency services on the family's behalf from hundreds of miles away, a chain of events set in motion entirely by a 9-year-old's quick thinking under circumstances no child should ever have to face. Rather than seeking emergency medical help for her husband Margaret, described by witnesses at the scene as highly intoxicated, instead gathered both of the minor children and put them in the front seat of Greg's truck, fleeing the installation. As she approached the base's perimeter gates, however, she appeared to lose her nerve, reversed course, and drove back onto Fort Riley property, where military police, already responding to the emergency call placed from Nebraska, intercepted and arrested her without further incident. Greg Schaaf, who had been shot directly in the face while holding his infant daughter, died from his injuries the following day. Because the shooting occurred on federal property, a military installation falls under federal jurisdiction rather than Kansas state courts. The case proceeded through the United States District Court for the District of Kansas rather than a county courthouse, prosecuted by federal attorneys rather than a local district attorney's office. What emerged during Margaret's time in custody, awaiting trial, added another disturbing layer to an already devastating case. According to accounts from jail staff and monitored communications later referenced in court, Margaret displayed what was described as a severe absence of remorse throughout her detention, reportedly speaking openly and casually about the shooting to other detainees, making disparaging remarks about her late husband, and, in a detail that particularly struck those who learned of it, apparently attempting to organize some kind of celebratory gathering behind bars on what would have been Greg's birthday. The turning point of the trial itself came from the same 9-year-old stepdaughter, whose composure had likely saved her infant sister's life on the day of the shooting. She took the stand and delivered first-hand testimony about what she witnessed. Her stepfather shot in a moment of uncontrolled fury, the aftermath she encountered in that bathroom, the decision she made in that instant to protect her baby sister rather than freeze. U.S. Attorney Ryan Kriegshauser, addressing reporters after the verdict, said plainly that Margaret Schaaf deserved to go to prison, emphasizing that the evidence showed she had murdered her husband while the couple's 2 young daughters were present in the home, and specifically praising the bravery of the young witness whose testimony had proven so central to the case. On February 14, 2025, a federal jury found Margaret Schaaf guilty of second-degree murder. On September 26, 2025, a federal district judge handed down the maximum sentence available under federal sentencing guidelines, 293 months, or 24 years and 5 months, in federal prison without the possibility of parole under the federal system, which does not offer the same parole eligibility structures as Kansas state sentencing. For the family left behind, 2 young girls now growing up without their father, in the aftermath of an act their own mother committed, the case stands as one of the most painful examples in this entire documentary of how quickly an act of love, a father choosing to stay for his family in a moment of crisis, can be answered with unimaginable violence from the very person he stayed to support. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. Before we move on to the next case, take just 2 seconds to make sure you're subscribed so you never miss another gripping true crime documentary. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. Case 8. Lindsay Nicole Blansett, December 14, 2014, Wellington, Sumner County, Kansas, Sumner County District Court. There is perhaps no case in this documentary that forces a more uncomfortable question than the one involving Lindsay Nicole Blansett, not a question of what happened, which the evidence and her own words make painfully clear, but a question of how a mother's mind can become so distorted that an act of profound violence is experienced from the inside as an act of love and protection. Shortly before midnight on Sunday, the 14th of December 2014, in the small south-central Kansas city of Wellington, 33-year-old Lindsay Nicole Blansett entered the bedroom of her 10-year-old son, Caleb. He was asleep, as any 10-year-old should be at that hour on a Sunday night, with no reason whatsoever to suspect that the person walking through his bedroom door, his own mother, had arrived carrying a heavy rock and a large kitchen knife. Blansett struck her sleeping son over the head with the rock. The force of the blow fractured his skull and woke him, and in the brief, terrifying seconds that followed, Caleb, now conscious and beginning to understand what was happening to him, cried out the words that would later be recounted in court with devastating effect. "Mom, stop!" His mother did not stop. She pinned him down and stabbed him 7 times in the chest, killing him in the bed where he had gone to sleep only hours before, expecting nothing more than an ordinary school week ahead. What Blansett did immediately afterward stands in stark, almost incomprehensible contrast to the violence she had just inflicted. She did not flee. She did not attempt to hide what had happened. She picked up the phone and called 911 herself, calmly reporting to the dispatcher that she had just killed her son. Officer Sarah Owens, the first responding officer to arrive at the Wellington home, later testified that she found the house completely dark, and Blansett in what she described as a daze, standing near her other daughter, who was crying, while Caleb lay on his back on the bed, blood covering his chest, with no pulse. The explanation Blansett offered to detectives in the hours and days that followed is, in many ways, the defining feature of this entire case, a rationale so disturbing precisely because it wasn't rooted in anger, jealousy, or personal grievance, the motives that drive most of the other cases in this documentary. Blansett told investigators that she had become consumed by an obsessive, escalating fear about her son's future. A conviction that the world Caleb was growing up in had become irredeemably dark and evil, and that his life, if allowed to continue, would be filled with suffering she believed she could not protect him from by any other means. She stated explicitly that she wanted Caleb to, in her own words, go to heaven that very night, to spare him from what she believed was an inevitable future of pain by ending his life while he was still young enough, in her distorted reasoning, to be spared it. The case that followed centered almost entirely on the question of Blansett's mental state at the time of the killing. She underwent extensive psychiatric evaluation at Larned State Hospital, Kansas's primary state facility for forensic mental health assessment, and was ultimately found legally competent to stand trial, a determination distinct from and not dependent on whatever mental state she may have been experiencing on the night of the crime itself. At trial, her defense team argued that Blansett had been suffering from a severe and undiagnosed mental illness at the time of the killing, one that had convinced her, in a break from reality, that malicious people were actively coming to her house with the intent to kidnap and torture Caleb, and that her actions, however horrifying in their result, sprang from a genuine, if catastrophically distorted, desire to save her son from a worse fate. Prosecutors countered by presenting a forensic psychologist's assessment, suggesting that whatever mental illness Blansett may have been experiencing, she had nonetheless demonstrated the capacity to formulate clear goals and intent, that her actions, methodically retrieving both a rock and a knife before entering her son's room, reflected planning rather than the disorganized behavior typically associated with a full psychotic break disconnected from goal-directed reasoning. In October 2015, a Sumner County jury rejected the insanity defense and convicted Blansett of premeditated first-degree murder, along with a related charge of aggravated assault tied to the attack on her son. The district court imposed a hard 25-life sentence, meaning Blansett will not be eligible for parole until she has served a minimum of 25 years, along with an additional concurrent sentence on the assault charge. Blansett did not accept the verdict as final. Her appeal to the Kansas Supreme Court centered on a technical but significant legal argument, that the jury instructions given at trial had improperly prevented jurors from fully considering how her documented mental illness may have affected her capacity to form the specific intent required for a premeditated murder conviction. The state's highest court considered the argument carefully but ultimately disagreed, ruling in March 2019 that premeditation under Kansas law constitutes its own distinct mental state, one not automatically negated by evidence of mental illness, in the way the defense had argued, and upheld both her conviction and her sentence in full, closing out her final avenue of appeal. Kayla Blancett's case remains, for many who have followed it, one of the most difficult to process in the entire history of Kansas child homicide prosecutions, not because the facts are unclear, but because they resist the simple explanations that make other cases, however horrifying, at least comprehensible. There was no history of documented abuse leading up to that night, no escalating pattern of violence investigators could point to in retrospect, no external warning signs that a community or a welfare agency might have caught. There was instead a mother whose love for her son became so entangled with fear and delusion that it manifested as the very violence she believed she was protecting him from. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. Before we move on to the next case, take just 2 seconds to make sure you're subscribed so you never miss another gripping true crime documentary. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. Case 9. Heather Jones, September or October 2015, remains discovered November 26, 2015, Kansas City, Wyandotte County, Kansas, Wyandotte County District Court. Some of the cases in this documentary involve a single moment of violence, an argument that spirals out of control, a rage that erupts and ends in tragedy within minutes. This is not one of those cases. What happened to 7-year-old Adrian Jones unfolded over the course of an entire year, inside a house equipped with the very technology that should have made it impossible to hide, and it stands, even among the darkest cases in Kansas history, as one that investigators, prosecutors, and law enforcement officers with decades of experience have described as among the worst they have ever encountered. Adrian Jones lived in Kansas City, Kansas, with his father, Michael Jones, a former bail bondsman, and his stepmother, Heather Jones. To understand the full weight of what occurred in that household, it helps to understand a detail that seems almost impossible to reconcile with everything that followed. The home was extensively wired with surveillance cameras. Michael and Heather Jones had installed cameras throughout the residence, likely investigators would later theorize for their own purposes of control and documentation. Whatever their original intent, those cameras would ultimately become the most damning piece of evidence in the entire case, capturing, in stark and unavoidable detail, the full scope of what was inflicted on a 7-year-old boy over the better part of a year. According to the case prosecutors built using that footage and corroborating evidence, Adrian's daily existence in that home bore almost no resemblance to anything approaching a safe childhood. He was frequently kept in handcuffs. He was strapped, at various points, upside down onto an inversion table, a piece of equipment designed for adult back therapy, repurposed as an instrument of restraint and control against a small child. He was bound using medical splints. He was subjected to shocks from a specialized device known as a zap enforcer, an electrical training tool never intended for use on a human being, let alone a child. For extended stretches, reportedly running into months, he was locked, entirely naked, inside a pitch-black shower stall, denied even the basic dignity of clothing or light. The justification offered for this campaign of cruelty, when investigators later pieced it together, was almost unbearably banal in its pettiness. Adrian was frequently punished under the pretense of correcting behavior like stealing food, a framing that suggests a child so systematically deprived that he was reduced to seeking out food any way he could, only to be further punished for that desperation. Over the course of months, subjected to this sustained pattern of physical torment and deliberate deprivation, Adrian was essentially starved. In the early autumn of 2015, his small body could no longer sustain the damage that had been inflicted on it, and he died. What Michael and Heather Jones did next transforms this case from an account of extraordinary cruelty into something that also involves a level of premeditated evidence destruction rarely seen even in the most severe child abuse prosecutions. In the aftermath of Adrian's death, the couple purchased pigs and brought them onto the rental property where they lived. They then took Adrian's remains to the family's pigsty and fed his body to the animals, a calculated effort to eliminate any physical evidence that might connect them to what they had done, treating the disposal of a child's remains as a logistical problem to be solved rather than an unspeakable act layered atop an already unspeakable crime. For nearly 2 months, Adrian's death went entirely unreported. It was only chance, the kind of chance that so often determines whether a hidden crime like this is ever uncovered at all. that finally broke the case open. On Thanksgiving Day, November 26, 2015, police responded to a domestic disturbance call at the property after Michael reportedly fired a gun at Heather during an altercation between the two of them. Officers on scene, working the domestic incident, received a tip from a relative directing them toward the outdoor barn on the property. What they found there, human skeletal remains inside the pig enclosure, set off an investigation that would ultimately expose the full year of documented torture captured on the couple's own surveillance system. At trial, and throughout the legal proceedings that followed, Heather Jones attempted to present herself as a victim in her own right. A woman, she claimed tearfully in court, who had been too terrified of her abusive husband to intervene on Adrian's behalf. Someone who had felt trapped and helpless within the same household where Adrian was being systematically destroyed. It was a defense that might, under different circumstances, have found some sympathy, but prosecutors had access to something that made the claim exceptionally difficult to sustain. The surveillance footage itself, which, according to court records and statements from investigators, showed Heather as an active, and, in the words used by law enforcement at sentencing, an enthusiastic participant in Adrian's abuse. Not a passive bystander cowering in fear, but someone directly engaged in inflicting the torment documented on camera. One investigator would later tell the court that Michael had admitted Heather personally used the Zap Enforcer device on Adrian for stretches of 15 to 20 seconds at a time. In November 2016, faced with the overwhelming weight of the video evidence against her, Heather Jones pleaded guilty to first-degree premeditated murder and child abuse charges. She was sentenced to life in prison, with a minimum of 25 years required before she becomes eligible to even request parole. Michael Jones, who had initially pleaded not guilty and was scheduled to stand trial separately, ultimately also pleaded guilty to first-degree murder and received an identical life sentence with the same 25-year minimum. At Michael's sentencing hearing, held separately from Heather's Kansas City, Kansas police detectives who had worked the case for years delivered victim impact statements of their own, an unusual but telling detail, reflecting just how deeply the investigation had affected the officers who lived with its details for months. One detective told the court that the abuse and torture inflicted on Adrian had been constant, 24 hours a day, not even pausing while the household slept, and that nothing in his more than 20 years of law enforcement experience had prepared him for what he encountered on the recovered footage. Adrian's maternal grandmother, Judy Conway, addressed Michael Jones directly in court, noting that he refused even to turn and face the family members who spoke, and said she hoped that continuing to tell Adrian's story publicly might help protect other children from suffering the same fate. That hope has, in at least one concrete and lasting way, been realized. Adrian's case directly inspired the passage of what has become known in Kansas as Adrian's Act, legislation that legally mandates any adult living in a household with children to report visible or known severe child abuse to authorities, closing a gap in Kansas law that prior to Adrian's death had left significant ambiguity around exactly who bore a legal duty to report what they witnessed. In a further reckoning with the systemic failures that allowed Adrian's suffering to continue undetected for so long, the state of Kansas later agreed to a $1 million settlement in a civil lawsuit brought by Adrian's biological family, who alleged that Kansas's Child Welfare Agency had received warning signs about the home well before his death and failed to act on them in time. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. Before we move on to the final case, take just 2 seconds to make sure you're subscribed so you never miss another gripping true crime documentary. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. Case 10. Sarah Gonzalez McLean, January 11, 2014. Lawrence, Douglas County, Kansas. Douglas County District Court. The final case in this documentary is in many ways the most legally and morally complicated of the 10. A case that began as a straightforward, seemingly cold-blooded killing, was prosecuted and sentenced as exactly that, and then, years later, was fundamentally re-examined in light of information about the victim that cast the entire event in a dramatically different light. Sarah Gonzalez McLean was 19 years old in January 2014, living in Lawrence, Kansas, in the home of 52-year-old Harold Sasko, known to those around him as Hal. Sasko owned several regional Sickening pizza franchise locations, and Gonzalez McLean worked for him. On paper at the time of the crime and for years afterward, as the case moved through the courts, the relationship between the two was described in the most basic, surface-level terms available: roommate and employer. What actually preceded the night of January 11, 2014, According to the account González Maclin later gave, and according to extensive investigative reporting that emerged years after her conviction, was something far more troubling. She had first come into Sasco's orbit at 14 years old. By 17 she had moved into his home. Confidential police documents examined by journalists years later described Sasco as a man who tended to gravitate toward girls who had already been through difficult circumstances, those who had experienced abuse, family instability, or trouble with the law. Patterns consistent with what child protection advocates describe as the deliberate targeting behavior of a predator. According to González Maclin's later accounts, corroborated by advocates who reviewed her case extensively, Sasco raped her repeatedly over a period of roughly 10 months, controlled her financially, coerced her into cosmetic surgery, and progressively isolated her from her own family, a pattern of grooming and control that left her, in the words used in her later clemency petition, in a state of sexual and financial servitude from which she could see no way out. None of that context was central to how the case was originally prosecuted. What the state presented at her 2015 trial was a calculated, premeditated killing that 5 days before the night in question, González Maclin had made a firm decision to kill Sasco. On the night of January 11, 2014, she crushed a large quantity of sleeping pills into his beer. Once he was fully sedated, she used plastic zip ties to bind his wrists and ankles. She then used a hunting knife to cut his throat, and he bled to death on the floor of the home. In the aftermath, she stripped the bedding from the scene, packed a bag of her own belongings, and took an empty picture frame from her room before fleeing in Sasco's car. Before leaving the house, in a detail that would become one of the most widely reported elements of the entire case, she used the victim's own blood to write a single word in large letters on the wall. Freedom. She evaded law enforcement for roughly a week before being located by federal authorities camping inside a national park in Florida and returned to Kansas to face charges. At her 2015 trial, González Maclin's defense pursued an unusual and ultimately unsuccessful strategy. Rather than centering the abuse she had endured, her attorney argued that she was not guilty by reason of mental disease or defect, presenting expert testimony that she suffered from dissociative identity disorder rooted in childhood trauma, and that during the killing itself, control of her body had passed to one or more alternate personalities the defense identified by name during testimony. The jury did not accept the argument. She was convicted of first-degree premeditated murder and sentenced to a hard 50, life in prison with no possibility of parole for 50 years, a sentence that, given her age at the time, meant she would not become eligible for release until she was well into her 60s. It is what happened in the years following her conviction that fundamentally reshaped how this case is understood today. Investigative reporting, advocacy work, and post-conviction legal review gradually surfaced the extent of Sasco's documented history and pattern of behavior toward young women in vulnerable circumstances, evidence that advocates and legal experts later argued should have shaped both her defense strategy and the jury's understanding of what had actually occurred inside that house, but never did. Separately, a review of her original trial uncovered a significant legal failing. Her trial attorney had, according to a subsequent finding by both parties in the case, provided ineffective assistance of counsel, specifically by advising her to reject an earlier plea offer that would have avoided the hard 50 sentence entirely, and by declining to pursue any defense grounded in the abuse she had actually experienced. In 2021, following a settlement of a habeas corpus petition González Maclin had filed years earlier, a Douglas County judge formally resentenced her, reducing her original hard 50 sentence to a hard 25, meaning parole eligibility would arrive after 25 years served, rather than 50. As part of the agreement, González Maclin gave up most of her remaining rights to appeal or pursue a new trial. There would be no opportunity for a jury to hear the fuller context of her relationship with Sasco and reach a different verdict. It was, by design, a narrower resolution, not an exoneration, not a reversal of her conviction, but an acknowledgement that the severity of her original sentence deserved reconsideration in light of everything that had since come to light. The resentencing did not resolve the case as cleanly as some had hoped. Sasco's own daughter, 17 years old at the time of his death, addressed the court through a letter read aloud by an assistant district attorney, pushing back forcefully against the narrative that had built up around González Maclin in the years since the trial. noting that most public attention had focused on Sarah's story and asking, in her own words, to be heard as well. It is a tension that remains genuinely unresolved in how this case is discussed today. A young woman who committed a calculated, deliberate killing, and a young woman who, by extensive documented evidence, had also been groomed and abused for years by the very man she killed. Both facts true simultaneously, without one fully erasing the weight of the other. Gonzales Mac-Lynn's advocates have continued pursuing clemency in the years since her resentencing, arguing that the totality of her circumstances warrants further reduction or her release. As it currently stands, her earliest possible release date remains February 1, 2039. Advocates for survivors of trafficking and domestic abuse continue to cite her case as a significant example of how the legal system has historically struggled to account for the experiences of abuse survivors who ultimately harm the person who abused them. A conversation that extends well beyond Sarah Gonzales Mac-Lynn's individual case and into ongoing debates about how Kansas and other states handle prosecutions in these deeply complicated circumstances. If you or someone you know is experiencing domestic violence, sexual abuse or trafficking, the National Domestic Violence Hotline is available 24 hours a day at 1-800-7997-233, offering confidential support to anyone who needs it. We've noticed that most of you watching haven't subscribed to Cold Case Hour yet. If you're enjoying the stories we bring you, don't forget to like this video and leave a comment. We'd love to hear your thoughts. 10 cases. 10 Kansas courtrooms: Butler County, Wyandotte County, Sedgwick County, Neosho County, Shawnee County, a federal courtroom serving Geary and Riley County, Sumner County and Douglas County. 10 families who walked through courthouse doors hoping for something the law calls justice, all of them already knowing, long before any verdict was read, that justice would never be the same thing as getting the person they lost back. When you step back from these 10 cases individually and look at them as a whole, a pattern begins to surface. One that is frankly uncomfortable to sit with for very long. In case after case, the warning signs existed before the worst thing happened. Natalie Garcia's own sister tried to tell the truth once already, years before she finally succeeded. Olivia Jansen's home had already drawn 5 separate police visits before the day she died. Anthony Bunn's grandmother did exactly what she was supposed to do. She called Kansas's own child welfare agency by name 7 months before her grandson was gone. Adrian Jones's suffering was captured, in real time, on cameras inside his own home, for the better part of a year, while the systems meant to catch exactly this kind of danger noticed nothing at all until it was far too late. These were not cases where no one could have known. These were cases where someone did know, a relative, a neighbor, an agency, a piece of paperwork sitting in a file somewhere, and where that knowledge did not translate into action quickly enough, or at all. And then there is the other half of this list. The cases that resist that same framing entirely because they didn't grow out of institutional failure so much as something more sudden and harder to legislate against. Rachel Hilliard's crime erupted out of an argument over a painting, a fuse so short that a 63-year-old grandmother lost her life before police could cover the distance a 9-year-old boy ran to save her. Dana Chandler's case took 23 years and 3 trials to resolve, not because the truth was ever seriously in doubt among those who investigated it, but because building proof beyond a reasonable doubt out of pure circumstantial evidence is one of the hardest things the justice system is ever asked to do, and because one prosecutor's misconduct nearly let it collapse for good. Margaret Schaaf's case is, in some ways, the cruelest inversion of all. A husband who chose to stay home, who chose his family over his deployment orders, answered with a bullet from the person he stayed for. And Kimberly Nibaga and Clint Nibaga's case stands as a strange, almost darkly absurd footnote in Kansas legal history. 2 people who believed mistakenly that a marriage certificate could function as a shield against the truth, only to learn that no courthouse loophole was ever going to undo what they'd already done in a field in Neosho County. Then there's Sarah Gonzales Mac-Lynn, a case that belongs in a category almost entirely its own. Convicted as a calculated killer, sentenced to 50 years without parole, and only years later did the fuller picture of who Harold Sasko actually was, and what he had done to her since she was 14 years old, come into public view. Her case doesn't offer the tidy resolution that true crime stories often promise. It asks a harder question instead, one this documentary doesn't claim to answer for you. What does justice actually look like when the person who committed a murder was also unmistakably a victim of the person she killed? Her resentencing in 2021 wasn't an exoneration. It was an acknowledgement that the first version of her story, the one presented to that original jury, was incomplete, and that incompleteness cost her years of her life before anyone in a position of legal authority was willing to reconsider it. What all 10 of these cases share in the end isn't a single cause or a single warning sign or a single fix that would have stopped every one of them. What they share is this: behind every docket number, every case file, every headline that ran for a day or two and then faded from the news cycle, there is a name that deserves to be remembered as something more than a statistic. Natalie Marie Garcia, Olivia Jansen, Mickey Davis, Dakota Patton, Mike Sisko and Karen Harkness, Anthony Tony Bunn, Greg Schaaf, Caleb Blancett, Adrian Jones, Harold Sasko. Every one of them had a life before the moment that ended it. Birthdays, favorite meals, people who loved them and are still right now living with what was taken. That's the part a court transcript can never fully capture, and it's the part we've tried hardest to hold on to throughout this documentary. If anything in these 10 stories stayed with you, if a detail about a warning that went unheeded, a phone call that was made but not followed up on, or a pattern of control that started small and grew, felt uncomfortably familiar to something you've witnessed in your own life, trust that instinct rather than talk yourself out of it. Every single case in this documentary that involved a child had, somewhere in its timeline, a moment where someone almost caught it in time. Almost is the word that haunts these files. If you're ever unsure whether a concern is serious enough to report, it almost always is. That closes out this look at 10 of the most devastating cases of women charged and convicted in homicides across the state of Kansas over the past 2.5 decades. Cases that took investigators years to close, juries days to deliberate, and families a lifetime to carry. If this documentary meant something to you, don't let it end the moment the screen goes dark. Drop a comment below with the case that affected you most, or the one detail you can't stop thinking about. We read every single one, and it genuinely shapes which cases we bring you next. If you haven't already, take 2 seconds right now to hit subscribe to Cold Case Hour, so you're here the moment the next investigation goes live. And if this one held your attention all the way to the end, do us one favor before you go. Hit like, so more people who need to hear these stories can find their way to them too. Until next time, stay aware, look out for the people around you, trust what you already know when something feels wrong, and we'll see you in the next case.